right, guys. Today we're going to talk about inaccuracies in credit reports, what consumers are most likely to come across, and then as we're processing them, what we're likely to see and how we should best deal with those. So, okay, so we've got inaccuracies. One of the primary things, we've talked about this before, that you're going to run across most frequently is the reaging situation, right? So, reage. Reaged accounts. So what is a reaged account? So an account should only be reported on a credit report, it should originate to some date certain, okay? And how do you establish what that date certain is, right? So you say something can only remain on your credit report for 7 years. Well, what does that mean? 7 years from what, right? And so the answer to that is it's 7 years from the last legal operation or the last statusing of that account. Legal statusing, let's say. Okay, and so what is legal statusing? Legal statusing can be, it was charged off, it was there was a judgment entered. It can mean that there was an agreement or a payment made on the account, the last payment made. Any of those things can trigger that legal statusing. Okay, so first of all, we have to think, well, what was the date of last payment? Because what can occur here, and what people don't realize, is the account can be charged off, right, in, let's say, 2011. And then somebody trying to do the right thing makes a payment in 2016. They make the payment in 2016. As part of that, the collector or the original creditor or whoever is servicing that account at that time says, well, we're going to do you a favor and we're going to take it out of this charged off status, and that will bring everything current, so just go ahead and make that payment. Well, what happens is when that payment is made, the legal status of that debt may change, right? For one thing, you've retold the statute of limitations, so you've restarted the statute of limitations. Another thing that might happen is you might you might call them up and say, hey, I'm thinking about declaring bankruptcy, and I'm going to try to work this out. Can you take it out of one particular status? Well, that has a serious impact. So you might not want to be negotiating like that. Might not want to be making those requests of the collector. So so you could have a simple status change by request. You could have make a payment. Okay, so these are gonna change the legal status of a debt. As a result, it's going to retoll the statute of limitations. It's going to also change the legal statusing in many cases, which allows the credit reporting company or the consumer reporting company to go ahead and leave that on your report for an additional 7 years. Okay, so reaged account. Something that should be pretty simple to start with, becomes much more complicated when you look at the facts. It's not just simply the charge-off date. You have to ask some additional questions. Well, did you make a payment on that? Did you negotiate with them in some way? Did you make a request to change the status of that account? Lots of different questions that need to be answered before we can quickly determine whether or not an account has been reaged. Now, one of the most common errors that I will see on credit reports, as far as it goes with reaged accounts, is the situation where the account is sold to a debt collector, so it's charged off, it's held on the books of the collector but then that account is sold to a debt collector. So it's a charged off account sold to a debt collector. Almost always what you'll see is the debt collector list that account as, charged off or aged from the point of sale, not from the point of charge off. Now that sale doesn't actually change the legal status of the debt. Just because somebody sells something doesn't change what it is. So therefore, that is an extremely common error. You will see that time and time again. That's one of the first things that you guys should be looking for when you're looking at collection accounts on a credit report. What's the date? When was it actually charged off? When did you make your last payment? These are questions you can quickly identify when working through somebody's credit report. Oh, well, this collector has reaged this account. Okay, so collection. So that's a simple one. You'll see that less common, right? The reaging issue, that's less common when you're dealing with an original creditor. You don't have that sale in there. You don't have somebody with little or no information about the account then posting stuff on a credit report, thus causing those errors. So, when you have that original creditor, much less likely to have that error. Now they still occur. And that's something that can be disputed, right? And it's meaningful. That's a real dispute, a meaningful dispute. It's not something where it's just technical. I mean, that's determining the date that this will fall off somebody's credit report. When that person might expect a significant bump in their score is driven by that date of, that original date of charge off or that last legal status date. So that is probably the most common error you're going to see. Another common error that you're going to see is just simply the wrong amount. Right, or a disputed amount. So that is obviously an extremely common problem. Now, where you'll see a defense as to the wrong amount, even when the amount is disputed or it's flatly incorrect or isn't pursuant to the terms of the contract, you go ahead, you run the disputes on that, no doubt. But I'll tell you, down the legal process here, we've seen these very contrived arguments by the CRAs and in some cases the furnishers. And what they'll say is, oh, this is not a factual dispute. This is a legal dispute. And we'll go into this in more detail actually in a later lesson, but factual versus legal dispute, what are we talking about there? Factual dispute, they argue, is something that can be determined from doing a proper investigation. So if you do the proper investigation, you can actually figure out the facts, and based on the facts, you should be able to determine the correct amount. Now, wrong amount is something that will often be able to be determined by facts, but nonetheless, you'll see this defense of, oh, well, actually that's a legal dispute. And so what is a legal dispute? So factual, we can look at the facts, so we can determine and calculate the amount. Legal dispute, they'll say, oh, well, it is the wrong amount technically, but, that's actually a legal dispute, because the question that needs to be answered is this contract term which provides for additional attorney's fees or something else that's been added into this debt, and that we're not able to do through a factual investigation. We need a judge to make a determination of whether or not legal fees or whatever it is applies to this account. We can't do it through a factual inquiry. Now, what you'll see in a supreme irony is that when we send disputes and a judge has said, you'll get a collection account, for example, and the collector will sue our client, and you'll go through a little mini trial, and the judge will ultimately throw the case out. They'll dismiss the case with prejudice, meaning the collector can never bring this suit again. And we'll go ahead and we'll take that judgment and we'll send it to the collection company. So a judge has told you what to do here, And the collection company will inevitably mail something back that says, we verified it as accurate. So even when they have stuff from a judge, they're not doing it anyway, but this is the defense that you see from them. It almost makes sense, except for the fact that, when you actually think about this, there is not a bright line rule between these things. And in fact, almost always you could describe one as the other or the other as one. And this comes down to many times in the legal process of convincing a judge it's one or the other, and some of preliminary motions before you were ever able to get to trial. So it's this kind of like sales game of like, well, what is it? But this is a very common defense that you'll see coming out from CRAs and in many cases furnishers who have not engaged in any actual effort to investigate, but have just simply looked at a database or parroted the same information right back to the CRA. And the CRA, in supreme irony as well, hasn't actually even attempted to do any investigation. They've just simply taken whatever the original creditor or the trade line placer or the furnisher of the information has sent to them originally, and they just send it back down to them. If that entity verifies that information as accurate, they say it's accurate. So they're not engaging in any factual determination. They're not engaging in any legal reasoning. There's no effort whatsoever there, but nonetheless, they'll bring this defense of, well, we couldn't possibly do that because, this would require a legal determination, even though we never even made any attempt to look at the facts or actually look at the account to determine on the front end whether or not one of those two things would apply. That never occurred. But once this consumer has gone through the process of disputing and jumping over all the hurdles necessary to bring a proper FCRA case, then they will raise this defense. I think it's ridiculous, but nonetheless, you will see that. So that's kind of the wrong amount in a nutshell. We dispute them. That's a factual process for us on the front end of crafting that dispute letter to make sure that it captures the right information and the issue, and try not to make it a legal dispute, right? When crafting it, it's got to be try to put facts in there. The account was charged off at this, and then I agreed to this interest rate, and as you can see from the calculation, it's not correct. That might be an extreme example. I don't necessarily expect that, but that would be the ideal situation. Finally, another thing that we might see is statusing for bankruptcies. So bankruptcy, BK here. So bankruptcies, basically, you'll have an account that was included in a bankruptcy estate that should be charged off due to bankruptcy, but that will be being reported as as an open account or due and owing. And okay, so you'll see these bankruptcy problems. Those are very common as well. So these are probably the three main areas that you'll see. Then we kind of get into we might be able to start a new field here, but okay. So then we get into some other areas that we see less frequently, but are certainly inaccurate information. And one thing I should have started with when we did this is, what is the definition of inaccurate information under the FCRA? So that's kind of a preliminary question, right? Before we, I guess, get into this, we should really think, what does it mean to be inaccurate? And a very interesting fact here is that the FCRA doesn't actually define inaccurate information in it. It said, or CRAs, when posting information about consumers must assure maximum possible accuracy. It said, has that people should not post inaccurate information, but it doesn't actually define what inaccurate means. And well, we can look to a dictionary to figure out what inaccurate means. So I think there's a good argument that Congress probably shouldn't need to define that. But courts have done a good job of, as they do, interpreting statutory language to wrap some cleaner definitions around what is inaccurate information. And one of the things that they've come up with is they've said, look, inaccurate information within the context of the CRA, FCRA, means more than simply simple accuracy as you might get from a dictionary, okay? And that's because the FCRA has in it this requirement that you assure maximum possible accuracy, right? So there's obvious intentions to mean more than just accurate, like really accurate. And when we say really accurate, the courts have, as they do, put much more poetic language around this, and they've said, look, anything that is inaccurate from a factual standard or from a technical standard, technically inaccurate, as well as things that are misleading. Okay, so something could be technically accurate, however misleading. And I actually had a recent case on this that illustrates this point very, very well. And the case involves somebody who was an authorized user on an account, okay? So what does it mean to be an authorized user versus a cosigner? An authorized user is just somebody who the person who is responsible for the account adds as an additional user, right? This person can charge things to my account. I am ultimately responsible. They are not in any way responsible, but I am giving them authority to charge and use my name, okay, and my good credit. By contrast, a cosigner has actual legal responsibility for the loan. In the event that that person doesn't pay, I then will pay it, okay, as a cosigner, okay? So distinction here is that the authorized user, although able to charge things, has no legal responsibility for ultimately paying the bill, and that's by operation of an agreement with the creditor. Okay, so authorized users on credit cards is where this came up. This guy, his husband took out a credit card, his ex-husband, I should say, took out a credit card, and he added this individual as a authorized user on the account, okay? This individual and his ex-husband later became divorced. This individual never used the credit card, never charged anything to it, never nothing. And he went out and he applied for a mortgage. And we'll talk about posting this negative information after somebody applies for a mortgage and how this is occurring in a later lesson. But at any rate, shortly after he applies for this mortgage or starts his mortgage search process, what happened is Barclays Bank went ahead and they posted that this guy was an authorized user on an account that was charged off and was in default. And the scoring model, or the scoring company that this particular, the mortgage company that this guy selected used, they actually incorporated this information in their scoring model, okay? Which meant that the fact that he was an authorized user, he never even knew he was an authorized user, never used the account, knew nothing about this whatsoever. He was an authorized user nonetheless, factually, technically. Why was he an authorized user? Because the guy whose account it was said, this guy can use my account. So technically, was he an authorized user? Yeah, probably. He probably was, right? Factually, was he an authorized user? Did he have any idea that he was an authorized user? No, he did not. Did he ever use the account? No, he did not. Okay, so although it may be technically correct, and you may be able to put that on a credit report if the standard were merely technically correct, it is materially misleading to put that on his credit report because this guy didn't know anything about it, right? I mean, I told the federal judge when assessing this, and her perspective in this case, as they try to drive settlement was, well, it was technically correct, was it not? I mean, even if he didn't know about it. And, my retort to that was, well, look, there is a host of case law out there that has said it is not only technically correct, but it is also, materially misleading, or misleading information is also inaccurate information under the FCRA. So therefore, it's actually inaccurate by these common law definition of these terms as interpreted by several appeals courts all over the country. I believe the 4th, the 3rd, the 2nd, I think, have all addressed this issue. Ultimately that was inaccurate information. He mailed disputes. They verified, Equifax verified the information as correct. Barclays sent information up to Equifax and said, yeah, no, this guy's an authorized user, keep it on his credit report. Equifax mailed something back to this guy and said, look, we verified this information and you are an authorized user and it's going to remain on your credit report. Well, what ultimately happened is this guy was turned down for his mortgage as a result of this. An account he never knew about, never used, nothing. And and that is a prime example of how these distinctions and this technically accurate versus misleading comes into play in a very real life case. And that's another area that we'll see for errors as well, right? Is authorized users. Okay, authorized users. I mean, that's a prime area for inaccurate information and disputes, which we should be looking at. Okay, so now we should talk about kind of the big areas that we see in terms of these high value cases. These cases where you have something and it's not just one account or two accounts, but it's in many cases multiple accounts. 3 different areas that we'll want to talk about in terms of these kind of systematic errors versus a one-off error, or versus something where the person may actually be linked to the account, but there's something wrong within the account. So those kind of situations I think of as linked to an error within a trade line, and now we're kind of thinking outside of the trade line. So we're thinking, look, this trade line altogether should not be on this report. So error within trade line itself should not be on the report. And basically you see 3 categories for this kind of information. Okay, you see mixed files. Okay. You see ID theft. Oops. And then you see fragmented files. Okay. First things we talked about were internal trade line errors. Now we're talking about kind of these external, the entire trade line, the whole trade line shouldn't be there. And these are typically, from an FCRA perspective, more valuable cases, typically, because when you have a negative account on there, a negative trade line on there from a scoring perspective, that entire trade line being on there. So a collection account, let's say, there's a collection account and it has an internal error in terms of when that thing should drop off or the amount or something. But even if you corrected that, right, you're still gonna have a collection account on your credit report. Well, you might, I guess not, if the trade line was obsolete. So I shouldn't say that in all cases, but generally speaking, we're thinking about a situation where the end result is that trade line is still on. Whereas these situations, the trade line is off entirely, and that can, from a when we previously talked about like the necessity of expert witnesses and bringing in somebody who's an expert in scoring and all these things. Those expert witnesses will tell you that these cases have a much higher impact on the credit score itself thereby, excluding people from use of the credit system altogether, versus maybe having, some more minor changes in the scoring, perhaps, leading to a higher interest rate versus a total exclusion. And that goes back to that risk-based credit that we were talking, risk-based credit decisioning, where different scores give you different pricing versus just totally excluding somebody from the credit market altogether. So mixed files, what are we talking about here? So this will be situations where we see somebody who is like a junior, right? Similar name, similar information, maybe even same addresses at one point, and then they had different addresses. So, you kind of get the mother-daughter, father-son. Sorry, father-son, mother-daughter, yes. That kind of situation. So you get the junior or the third, that kind of a situation. You'll also see this where you just randomly have two people mixed, and that can be due to a variety of factors. For example, it can be somebody with a similar name or even an identical name, even though they might not have the same address or maybe even not live in the same city. But nonetheless, because the consumer reporting agencies have loose matching data, many of the time you'll have this situation where the loose matching data actually results in people's credit files beginning to be merged. Even though they have different social security numbers, there can be all sorts of different factors. They ultimately, those accounts end up on each other's credit reports. And I've had several of these cases. Most of them, I think, have been this junior third thing. I've had a few that are due to just some other factors or similar names, and accounts just kind of float onto the records. But nonetheless, these mixed credit file things can be absolutely detrimental if you have somebody who has an otherwise extremely high credit score. They pay all their bills. They have, none of the baggage that accompanies being poor in America, where maybe you have one or two, bad accounts on there, but generally speaking, you try to meet your obligations. But this could be somebody with an absolutely perfect credit score that then, their credit file has all this information of somebody who maybe, has a less illustrious credit history, and therefore it significantly drops that individual's credit score. And as a result of this, you have the situation where you have somebody who, who has an otherwise perfect score, and is thereafter, maybe they've worked really hard for this, they might not be the richest person in the world, and they're going out to buy their first house or whatever the situation, and now they can't do it. They're totally excluded from the credit market, right? You can imagine how high of a value case that is, because you don't see those, you might still see the consumer reporting agencies making these arguments, but they're gonna fall on deaf ears, because this person didn't have other issues or baggage. They really had a good credit score, and due to something that is totally outside their purview of control, they now have a tanked score and they're unable to participate in the credit market. Extremely high value case, right? Also, you might have a situation where somebody has a less illustrious credit history, but then still has even more negative accounts on there. And that person shouldn't be set aside either. That person might have qualified for a car, to get a better job, to get a better credit history, and now they weren't able to do that and they were excluded from the market. So you'll see kind of a range of things, but it has certainly the potential of these extremely high value cases within there. Another situation that you'll see is ID theft, right? So this is the situation where, a potential ID thief gets information. For example, we had the 2017 data breach by Equifax, right? And it was later determined that many of these social security numbers and addresses and driver's license information could be actually purchased on the dark web. Well, somebody could purchase those accounts, from one of a variety of data breaches and take out credit cards and change addresses, and then the information is actually linked to some of your characteristics, although it's not you. That is inaccurate information because it is not you. And the FCRA provides for, and we'll go through this in a later lesson, there's particularized steps that a CRA needs to take in the event that they are informed through a proper process that the particular account is due to identity theft. Okay, so so you'll see data breach, right? Is how this right? You'll see data breach stuff. You'll see somebody pull a credit card receipt out of the trash can. You'll see the parent take out credit cards in their kids' names. You see this actually, unfortunately, much more frequently than you would expect. Some of the times this starts with the best intentions of creating a credit history for the kids, and then they lose track of it and things get out of control and one error happens and the best laid plans go to go to disaster, and that's a really unfortunate thing. But nonetheless, it's identity theft, right? If the child didn't authorize it, then that's identity theft, and it needs to be disputed as such. There can be some implications, so we certainly have to talk through it. But that is something to be aware of. And then finally, you have these situations where you have fragmented files. Fragmented files are kind of an interesting thing, and typically I think where you'll see the source of this information is somebody will have like a court judgment against them, and the CRA will have difficulty matching that data to an existing file. Okay, so then they'll create a new file that has this person's new information, and it is actually linked to somebody who already had a file out there, but they didn't have good information, so they create this new file, and then another account comes up, right? Or there's a collection account or something, and it's skip traced and it matches to the address, so then they add another account in there. And then lo and behold, there's a bank account that shows up, and that bank account actually links to the same address as well, and therefore, before you know it, this person has two credit files. One with potentially other people's information in it, potentially only negative information, potentially only positive information, and then they have another credit file that has an entirely different set of accounts in it. And when they go to apply for something, the argument that comes up is, well, look, if you would have looked at it as a whole, all my accounts together, I probably would have qualified for this, but instead you only looked at my negative accounts and therefore I was turned down. So that's a very legitimate argument, and a situation where your dispute is almost the inverse of a mixed file or not really identity theft, but it's almost this inverse of the mixed file, in that you have two files instead of one file. But nonetheless, it can be just as detrimental to somebody as a mixed file. So it's something to be aware of. I haven't seen, honestly, a ton of fragmented files because of, that might just be, somebody saying essentially this account isn't on my credit report, and perhaps as Meyer, as a practitioner in this area, is just saying, well, they might not have reported it for whatever reason. So I think identifying these can be extremely difficult, but I expect that you guys are a lot more creative than me, and you might find a situation where somebody's like, hey, I don't have all these things on my credit report. Start thinking about it. It might be this fragmented file situation. Come talk to me, and we'll figure out what to do with that. But yeah, so that in total is kind of the main areas of inaccuracy that we see in the FCRA, and it's something that we need to be to be aware of, and kind of as you see disputes come up, you can kind of now place them in those 6 categories and think through, I think this is what's going on, or this might be the situation. And that hopefully will help you to draft better letters, to better identify where you're at in the process, and to put some logic around what otherwise is a completely disorganized, disorienting process. And if you can maybe have some structure around it, you can start to get to find that right path to correcting some of this information. So thanks a lot, guys.